Number 115, the people of the state of New York versus Mario Arjune. Counsel.
Good afternoon, Your Honors. My name is Janine Yunus. I'm from Appellate Advocates. I'm representing Mr. Arjune, the appellant. Mr. Arjune's attorney deprived him of the effective
Ms.
assistance.
Yunus, would you like rebuttal time?
Yes, I'd like to reserve 2 minutes for rebuttal. Thank you so much for reminding me. Mr. Arjune's attorney deprived him of the effective assistance of counsel by failing to explain to Mr. Arjune his right to appeal.
Didn't he get written notification of his rights, of his appellate rights?
Is this the notice that you're talking
Yes,
about?
correct.
At sentencing. He was given that notice, but that is not a very detailed notice. It just says you have the right to an appeal and you have the right to poor person relief. Now, Mr. Arjune was...
What more should go? Well, let me ask you this. If it was a more detailed notice, would that have been enough?
In this case, no, because Mr. Arjune was illiterate, as the record shows. Barely literate. He was unable to read.
So, Ms. Yunus, what is retained trial counsel's obligation here?
Retained trial counsel's obligation is to have a conversation with his client sufficient to allow his client to understand his right to appeal, how to pursue that right, whether that's getting poor person relief or retaining another attorney, the consequences of not appealing, which Mr. Arjune also didn't understand.
So his duty and obligation is impacted by his appreciation or understanding of the defendant's ability to understand? Is that what you're saying?
That's correct. I think that it's a fact-specific inquiry that depends on the particular client. And I would draw an analogy to other situations. The right to appeal is one of four areas in which the defendant is ultimately the defendant's choice. Another is the right to testify, pleading guilty, waiving a jury trial. And in those contexts, we don't expect it to be sufficient for counsel to just, well, actually, in this case, the analogy would be just the court to hand something written saying, you have the right to plead guilty and you're giving up your right to a jury trial. We expect counsel to engage with his client and to ensure that his client can actually understand what he's doing.
And so is part of it to give advice?
Yes, it's to give advice.
To discuss the merits of whether, what the grounds might be for an appeal, what the relative merits and demerits are, so on.
Exactly, yes. I think.
Is that the obligation of trial counsel, or is that the obligation of appellate counsel?
Well, it's the obligation of trial counsel. I believe that the case law and the rules clearly establish that. The department rules, the ABA rules, all prevailing standards of the profession require trial counsel.
So when you say the court rules, because there are some differences in the appellate division rules that the four departments had
Sure.
at the time this arose. Are you familiar with the new uniform rules of the appellate division, and are they different?
I was unfamiliar with any new rules.
Okay.
However,
You would say that it has to go by the second department rule that was in effect at that time.
it's not just the second department rule. I think that's one way of understanding counsel's obligation, but I do think it's a fact-specific inquiry. And in fact, the second department rules require the attorney to give the defendant written notice. In this case, I might argue that that was insufficient because Mr. Arjune was barely literate. He was unable to read anything beyond the most basic material.
So
There
even,
is. I'm sorry. Go ahead.
Ms. Yunus, getting back to the concept of the duty being defined by the defendant's ability, how would a court measure that? Well, how would they apply that and determine?
Well, I think
And what would the process for that be?
one of the ways in which we can do that here is looking at what happened. Mr. Arjune did not effectuate his right to appeal, and we have documentation. We have a psychiatric report saying that he's...
So the court would have to have a hearing and then measure the cognitive impairment of a particular defendant to determine whether or not the person understood the instructions?
Well, I don't think that would actually happen that much. I mean, it doesn't happen in the guilty
But take a
plea
step back a second here. Wouldn't it seems to me the point of weakness in the defendant's continual representation is that period from when a determination is made and then the appeal begins, right? That's the period we're talking about here. And there are various remedies that you could deal with if there is a problem. You're suggesting a hearing, which seems to be an entirely subjective analysis on someone's relative cognitive abilities to understand. To ask a court to say how well somebody can read, what grade level they read at, whether or not the form is sufficient for them, almost places an impossible burden on the court. But, let me finish. But what about the ABA rule, which says that there has to be, that counsel represents until appellate counsel is either assigned or comes in, or is the determination there's not going to be an appeal? What's your position on that?
First of all, we're not asking for there to be hearings. We're simply saying that the governing standards already require this of counsel. The Sixth Amendment already requires it. If you look at Roe v. Flores, Ortega, Seiville, all the rules
Well,
governing the
let's talk about,
profession.
without expanding Seiville, is there a remedy through the rules that could solve this problem?
I think there's a remedy through the quorum nobis situation as we have
No,
here. but we
I'm
would-
talking about, not just in your particular case, but that transition period, when somebody's got an attorney at the end of their trial, and then they've got to make a decision, and they don't have an appellate attorney yet. There's that period where right now they don't have an attorney, but the ABA rules say you continue on as counsel.
Sure.
And wouldn't that solve the problem? Until appellate counsel comes in, or there's a determination made not to appeal?
Sure, I mean, that would be ideal, but we're not even asking for that. We're just asking that for counsel to put his client in a position to understand his rights and how to effectuate them.
The reason I ask is because it seems the remedy of a hearing is more cumbersome and difficult to administer without a clear-cut standard than the more simple expedient of saying someone represents you and you continue on until appellate counsel is assigned. That expedient seems to be much clearer.
I wouldn't complain if that was the rule, but we're not necessarily asking
Counsel,
for
don't you
this.
also have something of a problem with the record? So I think the conviction's 2009, this is at least 5 years, whatever, later. The sentence is relatively minor, right? It's 6 months or?
It was 1 to 3 years, but
1
he
to
had
3.
served some period of that time.
And he files a notice of appeal. How do we know that this wasn't a decision? It's retained counsel at that point, that I'm not taking an appeal, the sentence is decent. Later on, there are collateral issues with immigration consequences, and now he wants to do the appeal. And all we have in this record is an affirmation from the attorney which says almost nothing and can be read in very many different ways. And there's no development of a record here to indicate whether or not there was a discussion on whether an appeal was worth taking. So how do you get by that and not have a flood of these types of motions coming back to the appellate division 5, 6, 7 years later on essentially abandoned appeals when there's no record of what the advice was that was given to the client?
A couple things. First of all, I believe that the record establishes that there was no conversation. Mr. Arjune says there wasn't. His mother says there wasn't. Counsel doesn't rebut that. He doesn't say anything like, I typically have these conversations. Based on the unrebutted allegations of Mr. Arjune and his mother, as well as what happened later, I think it's clear that there was no conversation. There was no warning to Mr. Arjune about what could happen later. As far as the floodgates issue,
And the notice is to no effect, the notice of appeal?
the notice, what do you, I'm
The
sorry,
notice of his right to appeal?
is of no effect.
No
and-
effect in that discussion, analysis?
We don't know if that there was attorneys routinely file notices of appeal with no conversation with their clients. As far as the floodgates,
I think the question is about the notice that was given by the court, presumably with counsel standing right there with the defendant when he received that notice, so counsel would have known that he got that notice.
Sure.
So isn't there some burden on the defendant to show that that wasn't enough?
It wasn't enough. I mean, he could,
Well,
he has shown that he does not lack that he lacks the capacity to understand that notice and to understand what to do with it.
But
and
he
how to-
had the capacity to know, with the help of his family, to retain an attorney in the first place. So I don't think we can just assume that. My understanding of our case law says that the burden is on the defendant to make a showing that his rights were abridged and that he could not have realized that within the 1-year period required by statute.
I think that's exactly what happened here. He couldn't understand that. And the fact that he was.
But that, you're stating that as a conclusion. I'm asking you, what showing did the defendant make as to that? Other than just his statement, which I
His
think he said
statements.
is not sufficient.
His statements, his mother's statements, the psychiatric report, which documents his low cognitive abilities.
So in Perez, there was one of the companion
Sure.
cases dealt with a 16-year-old.
Yes.
And that didn't seem to inhibit the court's ruling. So
I think there's also a situation where you have somebody sitting in prison for a number of years, so it's harder to understand how that person could not understand his right to appeal, and at that point, it might start to look like he actually gave it up, and it's just changing his mind down the road. Whereas in this situation, he was not in prison very long past the verdict.
So if I could take you away from the specifics of this case, what is the broader rule that you're advocating? Because it's going to have an impact, as Judge Garcia is suggesting, on many cases if we were to go someplace that you're suggesting. So what is the actual rule you want us to
The rule
adopt?
that I would advocate is that counsel must have some discussion with his client about his right to appeal, taking into account that client's particular situation, and ensure that he is able to take the steps that he needs to. Just to be clear, we're not asking for a new rule. We think that this is an application of the current rules that exist, based on Roe v. Flores-Ortega, Seibel, numerous other cases, as well as all the prevailing standards of the profession, which all say the counsels.
Counsel, let me ask you somewhat different also. Let's assume for one moment that the attorney, because he's filed this notice of appeal, tells him, you have the right to an appeal, I'll file the notice of appeal, you can go seek poor person relief, here's the document that tells you how to do that. And then, as in this case, later on, the attorney gets some letter indicating that the appeal hasn't been perfected. What would be the attorney's duty, in your opinion, in that hypothetical? Assuming that there has been some discussion, that's why you have the notice of appeal filed, even assuming there's been some basic information, look, if you can't, I know you paid for me, but if you can't afford a lawyer, you can go and apply for that, but doesn't fill out the form.
I think that if the first conversation was adequate under the rule that I've just advocated, then the motion to dismiss issue is less pertinent. That sort of shows the counsel's initial management of the situation was not effective, and he was then on notice that he hadn't done enough to impress upon Mr. Arjune
Well,
the
but that
importance.
assumes that in every case, the defendant will want to perfect the appeal, or couldn't there be cases in which they go to appellate counsel, and appellate counsel says, you don't have any, there are no meritorious issues.
There are almost always issues that can be raised on appeal, and this was
And
this was a
theoretically.
trial felony conviction. This was not a plea.
What I'm saying is that your rule assumes that if there is no appeal taken, that there was some lapse there. And that's not always true.
Not necessarily, but under the circumstances that we have here, it's clear that that's what happened, based on what Mr. Arjune says, as well as his mother, and based on counsel not rebutting that and not saying that he did have such a
But
conversation.
couldn't the appellate division, which I assume they did, look at all these things? They had the affidavits, they had everything, they applied Sayville, and they say no. What's our standard, if there's no new rule, what's our standard for reviewing that decision?
Well, the standard for reviewing it is that the appellate division misapplied the rule.
But couldn't it be that they looked at this affidavit, which says nothing either here nor there, or the attorney, it leaves certainly a lot of room for there to have been these types of conversations, looks at the timing, looks at all these other factors, and decides, no, our court, appellate division, is not going to hear this. We're not going to let you do this. And now we're reviewing their decision based on kind of what almost seems like should have been a hearing. How do we do that?
Well, I'm not sure what the appellate division's, the basis for its decision is. They didn't really write on it, but it's clear to me that they did not properly apply the standards that exist.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. William Brannigan for the people. May it please the Court. Your Honors, defendant failed in his burden to establish in his motion that he received or that he was denied his right to appeal by ineffective counsel. The papers he submitted, including an affidavit from the trial attorney, which didn't say what advice he gave and what discussions they had regarding the appeal, along with his own motion where it said he knew nothing about his appeal, and that was
Counsel, I'm going to change the hypothetical a little bit. Let's say that the record makes clear that the attorney did nothing other than file the notice of appeal and that the defendant got the form that was handed out in this particular case. And then the lawyer gets that letter that it's not been perfected. Does the lawyer at that point have any duty and obligation, that trial counsel?
Your Honor, if the defendant was notified of his right to appeal, at that point,
With the form, and that's all that's been used as a notification.
With
Take
the
this
form.
hypothetical
With
as
the
presented.
okay, no, I'm taking it, and I'm assuming that he read the form, okay? Then at that point, as far as the constitutional, far as the constitutional issue, he wasn't prevented from his appeal by ineffective counsel.
Well, can I ask you about the constitutional issue then? Because there are a few pieces of Flores-Ortega that I'm not sure are consistent with the last answer you gave. So Flores-Ortega says, counsel has a constitutionally imposed duty to consult with the defendant about an appeal when there's a reason to think that a rational defendant would want to appeal. And it says, we employ the term consult to convey a specific meaning, advising the defendant about the advantages and disadvantages of taking appeal and making a reasonable effort to discover the defendant's wishes. Then it goes on to say, it has a hypothetical that is very much like the notice here, although it's not a written notice. It says, there could be a situation where a sentencing court's instructions to a defendant were so clear and informative as to substitute for counsel's duty to consult being defined earlier in the opinion, and then says in that circumstance, counsel might reasonably conclude that he or she didn't have to repeat that information, essentially. But how is what happened here not a violation of what the court says in Flores-Ortega?
Okay, I'm sorry, are we still in the hypothetical, or
No, let's take the actual language of
Okay.
Flores-Ortega and the language and the facts here.
Okay, Your Honor, if, again, we'd have to presume, like, let's say we presume under that rule that basically nothing was done. First, I'll say, yes, if he read the thing and he didn't turn to his attorney and say, I'd like to appeal my conviction, or, well, I don't know, or said something to that effect. The attorney at that point, files the notice of appeal, assumes that the defendant, 2 years later, when he gets the motion to dismiss, assumes that the defendant did not wish to take the appeal. Then, under those circumstances, we couldn't say that he was prevented from filing the appeal by the ineffectiveness. Now, if again, in this case, our argument.
Not a question
Are you
about being
saying that because, I'm not, your argument isn't clear. Are you saying that because Flores-Ortega has to do with the filing of the notice of appeal itself? Are you making that distinction?
No, Your Honor. There's two things. One is that the attorney actually filed the notice of appeal, which he did there, and that the defendant received the written notice. Now, our argument is that the appellate division can take the inference that there was some discussion between defendant and his attorney about whether to pursue the appeal, and that the fact that he didn't was because he didn't wish to pursue the appeal, whether that's because he got acquitted from the top count or for some other reason we don't understand. But that it was the defendant's burden to establish, and in particular establish what counsel did. Counsel never said what he did in this case.
See, I had thought that notice equated to the minimal contact that was necessary to satisfy Flores-Ortega. I thought that was your argument, and then you were saying that, but Cyville, while it does demand notice, it does not require, you don't want the rule extended to perfection of the appeal. That's where I thought you were ultimately going.
Yes, once he is advised, once he is told that he has the right to appeal and that he can apply for poor person notice, which he is in the notice, and once the notice of appeal is taken care of, the defendant under West has some obligation to fill out the poor person paperwork and send it to the appellate division if he wants to go forward with his appeal.
Mm-hmm. I'm not really clear why you're saying the form in this case replaces advice by counsel.
Your Honor, the form in this case tells the defendant that that he can, that he has the right to appeal, and that he can apply for poor person relief.
But the notice of appeal is filed, so that's not really what you're talking about. You're talking about the poor person filing?
I'm talking about the notice, the actual notice that he gets its sentence, which is given in every case in Queens, and I think throughout the
Yes, I know
state.
what you're talking about, yeah.
So
Well, the notice is actually different in different parts of the state, because in the first department, there's a clip-off, which is really clear, and this is how you do it, and you mail it in, and then they contact you to process the poor person relief, if you need it. And then so it's not the same in every part of the state.
I apologize. I was comparing, I thought, reading West and reading the notice, that issue there, I thought it was similar to the one that we used.
They're similar, but they're not exactly the same. And so the question, to the extent that under Flores-Ortega, you're going to rely on the courts giving the notice in such detail that it substitutes for the counsel's obligation, I'm not sure that this record is clear at all, what he got, because correct me if I'm wrong, you did put in a copy of the second department form that's given, but I don't know that it's really established in the record that that's the one he got.
Your Honor, let me step back for a second.
Yeah.
The trial attorney should advise the defendant about his right to appeal, all right? We are not saying anything different.
And consult with him about the merits, or no?
Your Honor,
Is that part of the constitutional obligation?
Your Honor, right now, as far as, no. But our argument here, even assuming that he did have that obligation to discuss that with him, our argument here is that the defense counsel here, what the burden as far as granting a quorum nobis motion is that they should have at least established what the conversations were between defendant and his counsel. And if counsel didn't remember in this case, which is possible, he should have at least said, this is my standard course of business in every case. I tell a defendant X and Y regarding his right to appeal. He must have told him something. He filed the notice of appeal. He said, well, it was known that I was not the appellate counsel, that I was only the trial counsel.
But does the case turn on, and you must have told him something? It's got to turn on more. But let's assume for the moment, we agree with you that at a minimum, he's told him, you have a right to appeal. So how does he notify him, though, and explain to him about how to perfect that appeal? How do you get that from the record?
Again, we can take, first of all, the fact that he files the notice of appeal, the fact that this slipped advising the defendant.
He's retained counsel, right? So it
He's
may
retained
very well
counsel.
be that he doesn't even think that it's necessary to have a conversation about indigency and the ability to get appointment of counsel for the appeal.
Your Honor, I don't know what his understanding was of defendant's indigency.
Well, that's
But
the-
again,
yeah.
So I think this brings us back to what Judge Fahey was alluding to with opposing counsel, which is, so do we have to have a hearing in each one of these to figure out what people knew and didn't know and what they were told? I mean, and does that become a cumbersome process? Or is there some rule that we can put in place that is more efficient and avoids having to do individualized findings?
the rule, as far as that goes, Your Honor, is that the defendant had to come forward with the facts. He presented this affirmation from the trial attorney. That affirmation should have been complete. It should have said what discussions were held, or at least what the course of discussions are between him and his clients. A hearing would only have to be held in a very rare case.
And so if the affidavit that wasn't provided, but if the affidavit said, I didn't actually have any conversations with my client about appealing, I just filed a notice of appeal, you would then say we should reverse here?
Your Honor, if he said that he told him nothing, we would probably still argue that this wasn't the cause of his forfeited appeal. But yes, we'd be in a much worse position at that point. We probably would have lost in the appellate division.
And
What if
what's
he
this?
s-
I'm sorry.
I'm sorry. What if he said, okay, you just got this notice, do you want to talk about it? Do you have any questions? Do you understand it? Would that be enough?
That type of conversation would be sufficient, yes, Your Honor.
May I, Chief, just ask one?
Yes.
So what's the standard the appellate division is applying in granting or denying this motion? What do you have to show at the appellate division?
You have to establish that your appeal was foregone because the attorney did something, and that could have been not giving the advice, that could have been filing the notice of appeal and not telling him that the attorney did something. And if you file an affirmation from an attorney, the affirmation should be complete, and the affirmation should say exactly what discussions they had regarding an appeal.
And so your point, I think, is your argument is this affirmation, which essentially says, after the conviction and the acquittal, I filed the notice of appeal, then jumps to, after that, I didn't have any conversations with him. And there's this gap in between where there could have been a lot of conversations around the filing of the notice of appeal.
That's correct, Your Honor. It's up to the defendant to fill that gap if he wants relief.
Thank you, counsel.
Thank you, Your Honor.
Did the defendant file a motion to reinstate the appeal at the appellate division?
Yes, he did. And that was denied. I just want to go back to the issue of
Is
the...
there anything, besides that, is anything in the interim years that defendant had an obligation to do? Did defendant have to exercise any kind of due diligence to find out what was going on or anything like that? I mean, we know he got at least a written notice of his right to appeal, and then nothing happens for a number of years. Is there some burden on the defendant to show that he was unable to ascertain his right to go forward?
Again, Mr. Arjune actually was unaware of everything because of his limitations. He didn't know what to do, and he was unaware once he got released from prison that there could be further consequences to his conviction, and he didn't realize that until he was put in ICE detention.
But, I mean, that's, well, go ahead.
No, I guess I'm not sure how, if he didn't realize any of these things in actuality, what he could have done.
Correct me here, what you presented was his own statement, his family's statement, who paid for the trial attorney, correct?
Yes.
And then some medical proof about his cognitive abilities. Is that
Yes.
correct?
Yes,
Is there
that's
anything else you put in?
Well, defense counsel's
I'm
affirmation.
sorry.
Yeah,
counsel's-
affidavit, yeah.
And the counsel's affirmation, I'm sorry. Yes.
I believe those are the things. Also, his immigration attorney's affidavit saying that she spoke with him. She was convinced that he didn't understand any of these rights, and she became aware after fairly limited interactions with him that he was cognitively impaired, and that's why she got the psychiatric report. Presumably, again, this was a trial. This wasn't a plea. Defense counsel must have had extended interactions with Mr. Arjune and must have known that he was cognitively impaired and that and barely literate, and that he would
But
need...
it's just as possible. I mean, he got acquitted of some pretty serious charges and ended up with a pretty minor sentence, and it's certainly possible that counsel did discuss it with him, and a decision was made not to perfect the appeal, and that he filed the notice of appeal just to make sure, just to protect his rights. But because we don't have anything from the trial attorney about, as Judge Garcia says, that gap, we don't know.
I think what we have from the trial attorney is as much as one can expect. It was years ago. It is understandable that he might not have remembered, but again, he didn't say he routinely had such a conversation. So based on that, Mr. Arjune and his mother's assertions were unrebutted, and I think it's very, the inference should be drawn that no such conversation took place.
Thank you, counsel.
Thank you so much.